All right, this is CR 0124-31665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horowitz. And on behalf of, when you should note the defendant is present with counsel, Ms. Taylor, Ms. Massoff, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has. Effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case, should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and may be noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
May I, Your Honor?
Of course.
Thank you, Your Honor. I will, I think, address Ms. Taylor's arguments sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and the counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clark needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete, and the experts didn't say we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials, and I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance, and to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorch the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
In federal court,
in federal court.
which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right, is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right, we'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
Please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already.